All right, let's talk about land trusts. What's a land trust? Well, it is a revocable trust. This is a key term here. It's a revocable grantor trust. Where did it come from? Well, it came from actually the Romans. They're the first ones that come up with these things. It can go way back. But King Henry VIII really took on significance in his reign because he wanted a lot of money. He had a lot of expenses. And when you have a lot of expenses, the way you get money is from the people whom you govern. And one way to do that in England at that time was to kill off the people you governed, because then you got their property. And then you could turn around and sell their property. I mean, after they took everything he could from the church, it was time to go after his own people. So attorneys and people got wise to that, and they said, wait a minute, if I die and I was put in this situation where the king sent me off to fight without any equipment, so I can see what he was trying to do, my kids, my wife, they don't get the property. They're going to be left destitute, because the king wanted to turn around and sell the land to somebody else who would actually put it to use. Because if you have property that's put to use, and that actually flows through our common law to this day. You ever heard of the term adverse possession? Okay, adverse possession allows you to take over control of somebody's property, and you own it if you work it. So if you find a piece of property out there and you go and you fence it in and you keep it fenced in for 10 years, it's your property at that point in time. Sometimes it's 7, depending on the type of use of the property. But the reason we allow that in our society is that this stems from the belief, going back to England, that we do not want land to sit fallow. That by putting land to use, it creates revenue for the realm, or for the country, that is, because you're generating tax revenue supposedly from utilizing your property. So we want to encourage its use. Now, given the fact that you want to encourage use of land, you need it put to use to generate revenue. That was the king's intent there. We couldn't give it to the widow because she's not going to be able to go out and work the land and bring in the crops, especially when you have mainly an agrarian society at that point in time. So we have to sell it to some other guy who can work another 40 acres. Now, if I own property and I realize that I'm forced to go and fight for the king, I don't want to give up my land if I die, because I've been working on it. So what they did is they created trusts. And we put property, or they put property into trusts at that point in time, and they would have an attorney who would draft the trust serve as the trustee. And the attorney would have no control over the trust, because they don't trust attorneys any more today than they did back then. And the attorney would just be there for title holding purposes only. So we would transfer title, they would transfer title into the Barley Trust, care of Cheatham attorney, dated, blah, 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 blah. That was it. And now, when they died, guess who the beneficiary of that trust was? Their wife, their kids. So title never reverted back to the king because the person who died didn't own the property any longer. It was held in this grantor trust, and it left the property to the kids. Well, you can see that eventually the king didn't care for this because he wasn't making any money, wasn't getting the property back. So he challenged that himself. He challenged that those individuals who were creating the trust, and so basically went to court. And the court at that time looked at it and they said, you know what, I can see your point. There's really no benefit allowing somebody to create a trust other than just to put to a trustee to have this fiction where somebody's actually going to manage property and nobody's really managing it. It's really the trust owner who's in charge of the property. So what we're going to do here is we're going to craft this new body of law called the statute of uses. It states that if you create a trust where the trustee has no power over the assets, then title reverts back to the grantor. So it solved the king's issue. He said, hey, if you don't trust your attorney to be your trustee, then you really didn't create a trust. You get the land back, and I get your land from you. So he's able to go back and get the property back from people who created this type of trust because it violated the statute of uses. The statute of uses requires that the trustee actually have some meaningful power over the trust assets, that he's not there for title holding purposes only. So this was the general body of law that came over on the Mayflower that we have adopted, which we refer to as the English common law. Now, from the common law, which is important to understand, is that you can draft statutes that codify law. That is, you take what is there in case law, which we refer to as a common law, and you turn it into a statute in your state. Some states have specifically adopted land trust statutes based upon common law. Many times the reason why you're going to adopt a statute is that you want to change the way common law operates in your state. So you're not happy with the fact that you can't create a trust with a trustee who has no powers because under common law it doesn't work. What you'll do then is you'll create a statute that says, in our state, you can create a trust where the trustee has no powers and it's a valid trust and that the property does not revert back to the grantor. And in fact, you know who did that? Illinois. Illinois was one of the first states to actually adopt a statute for land trusts. So they adopted a statute, and they did it for the people who ran Chicago at the time, which were mobsters. And they are people who wanted to profit. I mean, it's no different today than it was back then. You have politicians who wanted to profit from the laws that they passed, or they didn't want the laws to apply to them that they passed. And one of the laws they didn't want to apply to them they passed is that if you want to vote on a project that's going to go in downtown Chicago and you own property there, you couldn't vote on that project if you had property within so many blocks of this, because of course it's going to drive up the value of your land. So when they own property down there, well, that doesn't apply to us, because what we're going to do is we're going to allow there to be trust created where we have our attorney listed as the trustee of the trust, so nobody knows that I own it, so I can put that public work project right next to my property and drive up the value of it overnight. And that's what they did successfully. I mean, that's the beauty of a land trust, because it allows you to mask ownership of real estate. So Chicago or Illinois drafted this or adopted this trust statute that abolished, for this purposes, the statute of uses and allowed you now to create these forms of trust. Now, if you don't fall within one of these states, then trusts, the land trusts come under the common law. Now, in California, actually, we do not have a land trust statute in California, and if you were to talk to attorneys who are not familiar with this form of trust, they will tell you they do not exist here. I hear that a lot. Now, land trusts are not recognized in California. That's false. Land trusts are recognized in California, and in fact, California follows the Illinois-style land trust law, which is completely contrary to the English common law, which is, which our system has adopted in all 50 states. So that's a little unique in California, that the fact that they follow the Illinois-style land trust statute, but I would not count on that, and I would not bank my creation of trusts around that. When I create a trust here, I follow the English common law as far as the terms, and we're going to get into that here in a second. Now, with a land trust, you basically have three parties. You have the grantor, that's the person who establishes it or is going to fund the trust, who sets it up. You have the trustee, the person who is going to exercise some control over the trust assets. And then you have the beneficiaries, the person who owns the trust. Now, the beneficiary is also the person who actually is entitled to what we refer to as the bundle of sticks, the assets that are held inside of the trust. They're entitled to all the benefits that come from those. And they can control the trustee, tell them what to do. Classic examples, a story that comes to mind is with an individual, a friend of mine. He's a radiologist. There was a piece of property last year that he and another doctor wanted to purchase. It was, this ski area. Can't think of it. Hey, Carter, Leanne, where's that property? What's that mountain called? Oh, whatever. White Pass. So he wanted to buy this thing up at White Pass. Now the thing is that it's $500,000. The ER physician found the property. My friend had $250,000 for his 50%. The ER physician didn't have the cash on him. So that he couldn't come up with the cash to buy the property, so he had to go out and apply for a loan. For some reason, the banks wouldn't loan this ER physician $250,000, so he could then buy his half of the property. So My friend, we'll just call his name's Mark. Mark came to me and says, Clint, what do I do? I said, Mark, do you really want the property? He goes, yeah, but he doesn't have the money. Should I loan him the money? I said, absolutely not, because you don't want to be in partnership with somebody and you're loaning him money. If he doesn't repay you, it's going to create problems for you. So don't loan him the money. He said, but I want the property. I said, well, then buy it. I can't do that because if I buy it, that's going to upset him. So my solution was to create a land trust. I said, Mark, here's what we can do. We'll create a land trust. You'll be the grantor. You'll put money into the trust. I'll be the trustee. And then you and your wife will be the beneficiaries of this trust. I will then purchase the property in the name of the trust. So if anybody pulled title on the property, we'll put my name on as trustee. So we'll take it as the White Pass Trust, Clint Coons as trustee. So I would be the purchaser of that property. Then if the ER physician ever looked at title and thought that you stole the deal out from underneath them, he wouldn't see your name associated with the property. He'd see Clint Coons as trustee of this White Pass Trust, so he wouldn't even know you're involved. And Mark thought, oh, all right, I understand where you're going there. He goes, well, what happens, Clint, if I want you to resign and you won't resign? I said, it doesn't matter, Mark. You can always fire me as the beneficiary, because as the beneficiary, you have this type of control over me. You can kick out the trustee at any time. You're out of here. Most of the time, your trustee is going to resign his position. So the way we're going to set it up, I was going to be the trustee. I would then resign, so he wouldn't have to fire me. Mark would then become the trustee of the trust. Now, he said, well, Clint, maybe I don't want you to resign. So that's fine. I'll stay on as trustee as a friend of yours. He said, but could you sell the property out from underneath me? No. There's a lot of trust I have here from a friend, right? I said, no, I couldn't sell the property out from underneath me because in the trust agreement itself, it states that Clint has certain powers over this trust. Because in Washington State, I have to have certain powers as a trustee. One of the powers that I do not have is the power of sale, the power to mortgage the property. Okay, those remain with the beneficiary. So if I wanted to get a loan on that property, the bank's going to ask me for a copy of the trust. And they're going to look at the trust and it's going to say the beneficiaries are the only people who have the power to mortgage the property. So they wouldn't deal with me. They would then contact Mark and Leanne as the beneficiaries and say, do you want to do this? So my powers are restricted. So in a typical trust situation where you give the trustee powers, you're not giving them the main control of your trust. You're giving them the power to set rents, collect rents if you want to, pay bills only up to a certain extent maybe, but they don't have the power of sale, the power to encumber the property, which are the big ones. Those are reserved always to the beneficiaries. That's how a land trust works, and that's how it's been applied successfully by this guy right over here who built this thing. The same one he built in Florida. He built it with land trust. That's the way he built Walt Disney World. He set up a whole bunch of land trusts. He sent a team of attorneys down there. They bought options on pieces of property from all these farmers at pennies on the acre. And then they exercised them all at the same time. It was just phenomenal the way they were able to put Disney World together through the use of land trust, because every trust had a different name, so you couldn't track it back, and you would see that, I mean, if Walt Disney went down there and started buying it all up in his own name, you know people would jack up the prices of their property. So he did it through land trust to mask who was buying the property. I'll show you how that works out here in a second.